have notes specifically about this video. I didn't write anything down saying I must do this on this video.
Did you write anything down about the new opinion that you would come up with related to this video?
No, I did not.
I'm just moving on.
Yep.
And your opinion, ultimately, that you imparted to Mr. Lally in that meeting was that the car did not move and the snow did not move, correct?
Correct.
I think that's all I have.
All right. Did you want to follow up at all, Mr. Lally?
No, thank you, Your Honor.
All right. So, Trooper, you are all set for today. We will see you Monday morning.
Thank you.
Okay. All right. So you're moving to exclude this. I'll hear you, Mr. Jackson.
Your Honor, it's very clear that this is a blatant discovery violation. Commonwealth has at least the obligation to provide us with any new opinions that any expert is going to testify to on direct examination. They've known about this witness for not months, for a year, for a couple of years. They've known exactly what this witness has memorialized in his official report. They knew that the only thing that we had was the official report. They met with him 2 weeks ago. This has become a pattern of conduct by the Commonwealth over and over and over. We're finding these witnesses getting on the stand, finding out that there's been a sort of preemptive strike in some sort of a prep interview where they're coming up with new opinions, new conclusions, new facts. It happened with Jennifer McCabe. This new fact about coming up, going to Michael Lank's house. It happened with Officer Sarah, coming up with a new determination about what was said or not said at the scene that we had never heard before. That was also in prep session of some sort, or I believe it was. And then this witness, literally, it's not even like just was it light out or was it dark out. This is a completely new opinion based on evidence that we presented, both in or talked about in opening statement and have presented variously throughout this trial. And this officer gets on the stand and now has a new central opinion about whether or not we're right and that taillight lens could be cracked. That's something that should have at least been reduced to writing, and even if it was reduced to writing, it should have been excluded because it's a discovery violation. It's late. We don't have time to prepare for it, and we're caught off guard. I use the word at sidebar ambush, and I know that rankles the court, and the court doesn't like it, but that's exactly what it feels like.
Well, that's been used both ways here, right? So it's a word, let's just take it out of here, make your point, okay?
I'll see if I can come up with a synonym for it.
Well, I understand your argument, so focus on, just continue where you were, but no comment whether I like ambush or don't like ambush. It's a word I've heard a lot on both sides.
I understand, Your Honor. My point is the evidence that now is being sought should never be presented in front of you. We didn't have opportunity to get this in advance. It's very least been in the Commonwealth's possession for weeks. He took notes about it. He now says, well, I didn't take notes about that specifically. I don't believe that as far as I can throw him. I think he did take notes about it. He was shown the video. He provided a new opinion. Mr. Lally knew that he was providing a new opinion. And then the first time he discloses this opinion is in front of the 16 jurors, 15 jurors. We would ask for its exclusion, Your Honor. And I'll submit.
All right, Mr. Lally.
Yes, Your Honor. As far as the pattern, especially coming from counsel, I simply find it laughable. As far as Officer Sarif, I think what counsel is referring to was testimony that was in his grand jury testimony. He was crossed about whether or not it was in his report, but it was in his grand jury testimony. As far as Ms. McCabe is concerned, that was regarding reciprocal discovery that was given to the Commonwealth weeks into trial by the defendant. It was then shown to a witness, which is perfectly permissible. Counsel asked a question of Ms. McCabe on cross, and she was aware of the material based on the late disclosure of reciprocal discovery. So there's no violation there. As it relates to, and why I say laughable, Your Honor, is that I am still...
I don't like hearing you say laughable. Just
understood.
Stick to what the arguments are. And
with respect to this witness...
Hold on. Quit the finger pointing, name calling, things like that, please.
Yes.
I know it's been a long week. It's been a particularly long day. But just focus on what you want to argue to me.
And I apologize to the court for that, Your Honor. With respect to this testimony, it's well within his realm as a crash reconstructionist. This is a witness who's responded to and investigated hundreds of crashes involving damage to vehicles. Simply making an observation of contact between two vehicles or purported contact between two vehicles on a video. The force is self-evident, and whether or not that force is sufficient to cause the damage that he personally observed on the defendant's vehicle is well within his expertise, and should be permissible as far as for this witness to be able to testify to.
What about the non-disclosure to the defense? So showing this video and asking for an opinion. What about that?
So, Your Honor, what I would say is I did not show this video and ask this opinion. This is a video that actually the trooper mentioned to me that he had seen over the course of while the case was pending, probably over a year ago, that he had seen that video. What I showed him was the photographs of Mr. O'Keefe's vehicle and asked whether or not he observed any damage consistent with the damage to the taillight observing or popping up on Mr. O'Keefe's vehicle.
Why wasn't that turned over?
In hindsight, it should have been, Your Honor.
All right. So it's late. I'm not ruling here. I want to review everything. I would like, I'm not obviously taking any of the evidence home with me. I would like, if it's possible, for what your IT person did on the expanding, like he did this second time, maybe I missed it, but I didn't see the tire move this time. So I'd like that. I'd like that video, and I would like, what's the exhibit number here?
It's Exhibit 6. Do you want just that video, Your Honor?
And the pictures of the cars. Whatever was shown during this voir dire, I would like those emailed to me so that I can look at them this weekend while I'm deciding, or put them on a flash drive right now.
That's what I'm thinking.
I'm sorry, I can't hear you.
We'll do a screen record and get it to the court by email. We can do that. I just need an hour once we get back to home base.
Okay. All right, Ms. Gilman, will you burn what you have for me before we leave somehow?
Your Honor, if I could, I just want to close one loop.
Okay.
What I was referring to with Ms. McCabe, I want to make sure that this is clear because this has come up a couple of times. The only thing I was referring to, or what I was referring to, it's not the only thing, but what I was referring to with Ms. McCabe is after Ms. McCabe testified, days and days and days after she testified and she was excused as a witness, then we got the report from Lieutenant Tully about the new information that she disclosed on the witness stand. In other words, she was cross-examined about it, etc. And then after she testified and was cross-examined and gone, then we got a report that predated her testimony that was in the possession of the Commonwealth, or at least in the possession of Lieutenant Tully. That's what I was talking about. I just want to make sure the record is clear. We don't need to go into it any further.
Did you want to add anything to that, Mr. Lally?
No.
All right. So I'll see you Monday morning.
Look, all right.